Thanks so much, everyone, for joining us today. When we think about what the purpose of a federal privacy legislation actually is, would love to hear some of the thoughts there, and I'll open it up.
There is a patchwork out there now, a product of the American legislative system, and it has served us well in certain corners, but we do need to bring it all together. I'm going to throw two other ideas out there that I think may be themes of our conversation going forward. One is there are 150 countries around the world with comprehensive privacy legislation. We are a far outlier. That creates practical problems. The Schrems decision that came this week, these are conversations that we had 2003 to 2008 that led up to the process with the big data report, all of the issues with FISA and with telecom intercept, all of the issues around safe harbor and then privacy shield stem from the fact that we are an outlier because we do not have a privacy law. So there's an international component there that is an international commercial component, and it's an international marketplace and participation in the world component that I think is serious. The other is a consumer trust issue, and that is a product of any number of things, ranging from data breaches, the shine the light laws, beginning with California in 2003 or so, have done a little bit of a part there, but they haven't gotten at the sort of the accountability framework, the need to treat data well across the board, across all of the OECD principles, how you collect, how you use, how you store, how you secure, how you retain and delete. And so I think there's a consumer confidence issue there. And then some of the more recent issues, concerns over social media, concerns over digital advertising, concerns over perceived lack of transparency in how things are done. And I think that all of these are coalescing now and forcing us to think in a try to swallow the whole thing at once and come up with one comprehensive law to deal with all of it. And for a country that has not had a comprehensive law, that's a very tall order.
Even if we end up with federal legislation, whether and how that addresses health information, we could spend an entire hour talking about that issue in and of itself. But I want to use that kind of use case to show how challenging it is, especially when we have, focusing on innovation and companies like TextIQ that develop technology and want to bring that technology to market. It becomes such an incredible barrier to entry when, most entrepreneurs that are creating a business don't have law degrees necessarily. And so they're sitting there thinking, I've got this great idea, I want to bring it to market. And the cost of getting the legal advice and sometimes the level of sophisticated legal advice that you need in order to figure out the intersection of all of these laws and the costs for getting it wrong, right? You might build a product or service and a model, and if it turns out that you didn't follow privacy by design or data secure by design, and you end up sort of in this place where you have to then backtrack, you could potentially you're talking like valuation and the effect of the future of that product or technology. And so there's a whole host of ripple effect issues. So from my perspective, what something like federal privacy legislation can do, or at least developing greater uniformity, greater clarity, greater operability between the existing laws that we do have, what federal legislation or that potential for a more harmonized standard can do is it helps to level the playing field for tech and innovation. And I think that's one of the benefits. There are cons to that, and I think we're going to get into what some of the cons are today, because one of the things that we've seen in Europe, for example, which does have comprehensive legislation, is it's been a challenge for many of the technology companies that are founded in Europe to actually compete with their American counterparts. That's at least some of that's some of the arguments that are made in the competition versus privacy.
Is a federal privacy legislation really the best way of achieving some of those objectives, or are there other sort of considerations there?
Well, I think if it can be done, it's the best way. But buried within some of the things that Heather and Peter were talking about are some very difficult challenges. Harmonizing even just the domestic situation, requires settling on some preemption principles that have proven fairly elusive so far, and poses one of the bigger challenges ahead. But I certainly agree with Heather that the need for harmonization is very, very significant. And I would absolutely echo what Peter said on the international front. The fact that the United States, which has historically played such a leading role in internet governance, plays such a following role in this particular piece of what's come out of that, it's an anomaly, and it's very unfortunate. And I think I'm probably more on the pessimist side of the scale than perhaps others, because I think, unfortunately, the reason we have the patchwork in the United States is that there is not confidence among other lawmaking bodies that the United States Congress can actually get its act together, even in an area like this one, where there's actually fairly significant bipartisan support for the idea that we ought to be doing something meaningful here. Yes, federal legislation would be a big plus if crafted well, but if crafted poorly, could be also equally unfortunate.
At first glance, that may not be, a panel about privacy legislation may not immediately conjure up artificial intelligence, but would just love to hear a little bit about how those two things are linked.
Well, Omar, you raise a good point. One of the things that happens in these conversations a lot, that Peter's a very good countervailing voice for, is a focus on the negative. So there is a lot of discussion around the issues of AI, but it's usually in the forum of potentially designing algorithms that drive things that we actually find really objectionable, whether that's in the lending space or in other areas where law enforcement, or other areas where discrimination can take root and be kind of cloaked by the use of machine learning on top of a design that drives things towards a certain outcome. What I think we actually get less of, and maybe this is a community that can do work in this area, are the positive cases. Because especially in the work in unstructured data that your folks are doing, Omar, there's a real opportunity to get away from that while identifying truly life-saving or other extraordinary innovations. And so I think trying to make the case during this debate for all the good things that come from AI is something that more effort should go into.
I'll add to that. That's a really good point, Eddie. I'll also add to that, we're at such a nascent state of companies and governments working with AI. Frankly, I think we're at a nascent state of even understanding what AI is, right? You look at the definitions of AI and they look like what we used to call computing. It's anything where a computer makes a decision that a human being otherwise would make. And we're figuring out everything from the sort of 5 years ago knee jerk of I need all the data forever because someday it's going to be helpful in AI, to now figuring out precisely what data elements we want and how they're going to be used. But what we're also figuring out, and I heard a fascinating presentation recently by a group that is focused on auditing AI. And they're auditing AI for all of the issues that could go wrong. They're auditing AI for racial imbalance, for imprecision in what's happening with facial recognition and other issues. They're looking at disparate impact. And what they're doing is they're shining a light on it, and they're getting companies to retune, to rethink and retune. There are technologies that are being developed that I don't know if we could call them supplementing AI, or if they present an opportunity for data protection surrounding AI. A lot of near field on phone things, right? Access and authentication solutions that happen on a phone, facial recognition that happens on a phone, and where none of the data ever goes off. All of the work on partially shared keyed data sets, the creation of dummy data sets that are based upon the attributes of real data sets, differential privacy. My worry, bringing this back to the creation of federal privacy law, is at this really robust moment, at this moment of foment, with all of the technologies, not just to do AI, but to create protections surrounding AI, people are trying to legislate the bad things. And it's the bad things that they're seeing based upon what went wrong in 2017,
right,
or 2016 or 2018, when Amazon left out a neighborhood in Boston because their algorithm was poorly tuned. It's not to say that there aren't problems. There definitely are problems. I just think we need to develop a richer tool set around that.
great,
Right?
great point.
Look at, I'm sorry, Heather, I was just going to give the example. Look at what happened with GDPR with Article 22. Preventing, except under certain circumstances, decisions that are based solely upon automated processing, right? Well, solely wound up in the law, which nobody really quite knows what that means, but it's less than predominantly, it's solely. And now Europe is really struggling with whether AI is permitted before we sort of get out of the gate. Sorry, Heather.
No, not a problem. I was going to take your point and amplify it, because I think, well, the European Commission released guidance on artificial intelligence, right? Guidelines for building trust in AI that was finalized in April of 2019. And that's a principles-based framework. The principles actually match up nicely. It sort of takes artificial intelligence and sort of compares it. So I do think while there continues a debate around that word solely, there's absolutely other guidance and an acknowledgement of the importance of AI, and trying to find a pathway and a framework for building trust in AI in Europe. And on the heels of that, what we had was an executive order here in the United States from February of 2019, so around the same time, where following that executive order, sort of asking for a similar development of guidance here in the United States, we had the directors for the Office of Management and Budget, the Office of Science and Technology Policy, and the National Economic Council that came together to issue a memorandum which was titled Guidance for Regulation of Artificial Intelligence Applications. And so that memorandum, what's really interesting is when you take a look at that memorandum, it articulates a series of principles that actually map nicely to some of the European principles. There's a slightly different tone, which does focus a bit more on economic and tech and innovation, and sort of keeping America and its economy relevant here, if you look at the press releases around that. But federal agencies had 180 days from the issuance of that, so that's right around now or shortly before, to issue a report on how they intend to comply and adhere their own, both in terms of acquiring AI and rulemaking related to AI, and sort of do an analysis here that was public agencies here in the United States. And the principles that are articulated are developing public trust in AI, public participation, scientific integrity and information quality, risk assessment and management, costs and benefits, flexibility, fairness and non-discrimination, disclosure and transparency, safety and security, and interagency coordination. So, the backdrop, if you think about this concept of federal privacy legislation, and Eddie, I hear you focusing on some of the negatives, seeing this particular issue, because I know we talked about COVID and we talked about Democratic versus Republican. Well, I talked about that, some of the disconnect there. This was the current administration's proposal for addressing AI, and you hear those principles and you start to think, okay, we have some opportunity to find common ground here. And a lot of those principles are not objectionable, and for many privacy pros would say, yeah, we're headed in the right direction when I hear that.
Thank you again to all the panelists, and hope everyone has a great rest of your week.
Thank you, Omar.
Thank you. Thank you, Omar. Thank you, guys.
Thanks, everyone.
Take care.